Good morning, everyone. I would like to thank for the invitation to be here. Thank you, Bruna, especially for this important congress. I'll be brief because we have to stick to time and we try to be very disciplined, like professor. I just have a couple of comments to make, which is how valuable this type of event is. It is key that we do attend this kind of congress. Congratulations to all the planners because I know it is not easy to put up something like this. Congratulations to all involved, for those who come here to listen to the speakers, because with this type of event, we can build a lot together. We can also just try to diminish the burden of all this work that we have on a routine basis. Apart from building a lot together, we also work on knowledge and we also have this opportunity to be together with each other, look into the eyes of each one and interact. This is very important. And let's try to encourage this type of congress. As a second comment, I would like to go into the topic of this session, which is the transfer pricing, commodities, royalties, and intangibles according to the sixth method to the OECD standard. Whatever good is implied on the methodology used. I understand that transfer pricing has or originates from something that we cannot move away too much, which is to ensure the a fair tax burden, preserving the tax base of the countries involved in the commercial operations. Over the years, the legislation or this methodology has been studied and also branched out into several other areas because of the complexity of this topic. But it follows a logic, which is to try to have this fair base. And it is guided by the value of the operation or the market value of this operation. Everything that we use to describe this parameter has to follow the simplicity of this provenance, which is to identify what is that operation value if it was marketed by third parties. How would the market behave? As complex as it seemed to be, the market is based on facts and data. Certainly, taxpayers that are in that market know that widely have a lot of documentation available in it and have lots of data available and also technical reports to to form this fair base. I think that is also very positive the way that the Brazil has been, or the pathway that Brazil has been paving towards that. And especially the conversation between RS and the taxpayers is also very positive. And we have to encourage this type of attitude and work for it to work really be successful. Transparency and confidence or reliability is also something that are very important. And this should be the grounds for this. So transfer pricing doesn't have the purpose of just increasing income. The purpose is to build a fair tax base. Or tax authorities and taxpayers have the ability to do that in the best way possible. So Bruno, these are my initial comments. So thank you very much. And now let's hear our panelists. Thank you, Mariana. Good morning, everyone. So we're going to have a different dynamic for this panel. I'll always introduce the panelists with a question. To Daniel, to start off, Brazil since until 2023 has used these mandatory methods for commodities that also use the quotation price as a reference. What are some of the main differences between the current legislation and the previous one that established IPSEX method? And IRS also wants to regulate something for commodities in a more specific way. Is there anything related to the records or registration about RTC for commodities, for example, that is also in our legislation? Because there are some doubts, in particular with regard to the interval to be used or the statistical method to be used in those quotations. What is the data transaction for declaration in the RTC? And also the view of RIS as to the possibility of adjustments resulting from activities performed by other entities involving commodities, and in which potential situation we can have a reliability of fact, especially based on the PIC method. Is there any guidance related to this? Another question or another issue we face as to the is for contract. So should they be renegotiated this year? And what is the position of IRS considering the generating factor to income? Is this going to have any normative instruction to clarify all these aspects? Good morning, everyone. Good morning, Bruna, and my colleagues here, panelists, Professor Schroeder, and other colleagues. It's an honor to be here at this panel and to be able to speak about this. Some of you already know me. I speak about transfer pricing all the time. I'm Danielle Pratis and a tax auditor from IRS and also coordinator of the International Taxation Department at IRS and also participate in the process of designing transfer pricing project. We have a law that was passed. We also have a normative instruction that is based on the general law on this. As you know, now we have a process of consultation to address IPI or excise tax, which we called as in this process a specific consultation process, and also been working on the regulation related to service transactions. Now, answering your last question, Bruna, yes, we do plan to have a specific regulation for commodities. This is within our radar. We understand that this topic is a priority given the relevance of these transactions for the country. I believe that you all know that our team has very few members. I think that I am the one that do most of the work, not here on the table, but in practice. So it's not really easy. But I think that we have worked effectively and also produced the regulation in a very fast way. I think it's also important to point out that most of the countries do not have such a detailed regulation as ours. We have some specific cases like the US and other countries, but these are exceptions. And what we have in our law is to have something more detailed. And now we plan to also include some more legal safety to it.
Interesting to see in this process when we start talking with taxpayers and consultants and so forth, we see that there is in fact a call to have more regulation, assertivity, and security to shed light or define some terms that have a certain subjectivity within legislation. But on the other hand, we also hear some saying, well, perhaps now it's no longer interesting to have more regulation regarding the transactions and have more details. Perhaps better to leave the system more open with exclusively in guidance. We have to deal with these different expectations. Well, now talking a bit about the commodities, and afterwards I go to return to RTC, or within brackets, let's talk about regulation and commodities. The idea is to have a regulation that will not be detailed regarding products, main products that are traded in Brazil. So now we don't want to be that ambitious and uh, provide specific adjustments for specific products or related to certain indexes, quotations that trade with another sort of product should be related to. So the idea is to have something more broad and generic, and then later on, we have more breadth and take into account obviously the participation and expertise of the private sector to have a more detailed regulation for specific values chain and specific products. So this is our intention. Probably also in the sense something during this year and in the same format we adopted, always with public consultation, waiting for inputs of the private sector and so forth, because I think the experience of the public consultation was very positive for us. We, in fact, analyzed all the inputs received, some take into account, others not, regarding the past consultation resulting on the 26 2161 normative instruction. I have difficulties of knowing all the numbers, but if I'm not mistaken, this is the number. And there are those that say for the solution 127. Well, I cannot even recall my birthday date, so imagine. But the idea is always to keep this standard. And regarding the pain consultation, there was a fill on the previous one regarding the publishing of inputs. Now we will try to publish all inputs. Now, as for the specific point regarding differences, my opinion is important to put within context. In law 9430, we had the commodities mandatory methods. There was a ordinary use of cost methods. So for cap export, most companies used cap to calculate what we called parameter price. And if there was an unpleasant adjustment, we would resort to a PVEX, a cup. It was a methodology that do not result in arm's length methodology, agreeing or not, but the fact is that it was not arm's length results. It was a cost plus 15% margin. And 013 or 12, there was the introduction of commodities, PCI and PSEX methods of mandatory enforcement. And in this, we could see an increase, substantial increase of the payments made by taxpayers. So addressing the data of the legal entities, we saw at this moment, as the moment the methods became mandatory, adjustments for export 4.8 million went to 3.3 billion reais. It was a difference that was substantial. But following years, these adjustments they dropped again. Perhaps taxpayers fit to use the transfer prices to the new methodology, or perhaps new loops were explored, or both. Both methods, when we talk about commodities, we have the false understanding, to say so, that if you have a quotation, this is a market price, therefore it gives you an arm's length result. And it's not exactly like this. Unfortunately, those here with me at this table working on this area are aware of this. We have different specificities and differences amongst products of Brazil stress stands out for iron ore exports, soybean oil, a wide basket of products exported by Brazil, and one product it's one thing and the other completely different. So it's like a zoo with animals. And in fact, many times there are differences in products and different markets also. So there are several variables to be taken into account. This was not well addressed by the PC and PSEX law. Legislator back then started by common sense, and then based on this, you started to have several distortions in the use of these methodologies, perhaps because of the basic level that adopted by the legislation and law and the normative instruction. Both methods they were enforceable and mandatory, and they were applied to goods subject to quotation. Several debates regarding especially the doctrine based of this concept. Then we had lists of commodities, stock exchange, research institutes or agencies. The doctrine most advocate in favor that you should only enforce both methods if your exported product was exactly equal or with the same specs of those from the standard contract. And this generated or resulted in several doubts regarding taxpayers, and also some disputes arise from it. And furthermore, perhaps another distortion and relevant problem regarding the adjustments limitation. The law and EN limited comparability adjustments, and this also provided problems and detachment regarding the standard arm's length. And both methods they existed until 2023 with the adoption of the new system. What we have it's a cup, and I would say important to stress that this cup does not is not enforceable and mandatory, but for you to detach it. As for those products subject possibly to it, you have to have a good case evidencing that the reached result is not one arm's length. And why do I say so? Because it's applicable to its scope. The scope it's more restricted. I only apply this scope when I have physical products for which the quotation price that says stock exchange quotation or an index of a research agency, they are used by independent parties within a transaction. I.e., if a market uses a certain index of Platts as an example, probably you should use it also for pricing your exports to your controlled company. Therefore, as one can see, a priori, this methodology should be applied. Nevertheless, we know that there might be those cases that are exception where the use does not result in a good outcome, either because the number of adjustments to be made on the quotation price make the outcome not that reliable, or a different reason. And as I said, we have a definition more precise and restrict if compared to the previous legislation. The scope of use is sort of different. Another issue that's an important a difference is regarding the possibility of using research agencies index. According to the previous legislation, there was a preference for using quotations by stock exchange and standard contract for stock exchange quotation. And this resulted in a serious problem because for some specific products, the market does not use that much or very few future contracts by the stock exchange, and sometimes transactions are negotiated with indexes published by research agencies. So the previous legislation forced taxpayers to use a certain quotation that it's not the one used by the market. On the other hand, the previous legislation had a certain flexibility. Therefore, you have several stocks exchange listed on AN attachments, and the taxpayer could do a cherry picking and choose the one that would be more favorable, and again, not complying with what independent parties would do, compare the quotation of one stock exchange, the other one, and would choose the one with the lowest value, as an example. Now, according to the new legislation, of course, this is not possible. I have to choose and use market quotation. This is the one. And perhaps some adjustment that are necessary are done what independent parties would do normally. Another issue also relevant is regarding the pricing date. Well, when we talk about commodities, we notice that time is a very important factor when you are negotiating. If you buy a commodity and sell immediately, probably your margin would be very low, is what the market calls back to back trading. But if you buy commodity and let the time work on it, you have some external factors operate and the quotation can vary. Geopolitical factors, season, and these things have a play on it. Example, Brazilian corn. Before Ukraine war, it was 272, I think it was dollars, I don't remember. 3 months later, after the war, it became 372. So 372, sorry, so it rise in $100. A certain future contract of a specific commodity today is traded at $180. But when the future contract was launched last year, the quotation was $120, i.e., there was in 1 year the oscillation was $70. This is very important, it's substantial. So, what happens? By establishing transfer pricing, we must be specifically careful regarding the data of quotation. Data chose by the parties to establish the quotation to be used on the transfer pricing. If I leave this very loose, perhaps we face some problems of manipulation. Unfortunately, I'm not saying all taxpayers do so, but these are those things that happen. We have those cases reported regarding Peru, regarding the selling of gold, where the fiscalization was identified constantly and repeatedly the taxpayers chose lower price quotation for shipment. You have in Chile the state-owned company that say sold copper concentrate, made a long-term contract with 15 years term using the same quotation of 15 years ago. So I'm selling for 15 years using the same price. Of course, that independent parties probably would not contract in this way without seeing any sort of adjustment of prices. This is a point important that one must take into account. Current legislation makes possible taxpayers to choose the date for the quotation. Nevertheless, it has to be based on the principal arm's length. Taxpayers must choose the quotation date and take into account which parties, dependent parties, would do in the same situation, and in fact, that it gives privilege to the data they chose by the parties. Of course, this choice has to be guided by principle, and then this, in some cases, go through the idea of the options that are available that will be the subject matter of a panel tomorrow. And in order to try to share with you regarding the safety, regarding the transaction date for its price. Some countries introduce the record of the contracts. Assume taxpayers sign the contract for the transaction and set forth the terms and condition of the transaction. Is demanded that taxpayers to record or inform the tax administration the information. The date is informed that will be used to price. So the date of the quotation to price the transaction must be informed. We follow the same line. We put the forecast within the law, and there was a regulation regarding this obligation. It was last year, now during the beginning of this year, I don't know, recall precisely the day, introducing this obligation. The obligation will be better specified. We still have some doubts regarding taxpayers, regarding some expressions that are used by the law. It is demanded for the time being that it is informed to the excise and record this transaction after 10 days after the transaction. There's a doubt. What is the transaction date? And there's a certain concern or claim or call by the market that a transaction date to be the export date. Nevertheless, perhaps advancing things here, we understand that it could not take into account the transaction date. The starting point to count the term would be the export date. The idea is to be the date in fact they executed the business between the parties to the contract, although the price is not fully fixed. We know there's in the commodities market there are those situations that part of the price is fixed in the future. I can, as an example, trade negotiate a premium before, but the quotation to be used might be a future contract of November, and then one of the parties will have the option to choose the date whereupon it will future contract will be settled.
Anyway, we understand that it will not be appropriate to postpone the deadline so that it will work for exports, because then we will have still the same problem that we have today, meaning that the IRS would have that piece of information in a period that is too far from the negotiated time of the transaction. Unfortunately, this can also give way to some manipulation. I would like to close here because my time has already expired 10 seconds ago. Thank you, Daniel. Professor Paulo. So, in particular, about comparability adjustments to be made on quotation prices. In a comparative analysis, considering what Daniel has just spoken, until 2023, with lots of adjustments to be made, and the current law that will have some adjustments made to all the things, all elements that affect the price of the commodity in terms of price. We can state that adopting this annus would ensure a taxation of the same the same level, or will also have some subjectiveness related to that, and we still will keep the same disputes or controversies.
Bom dia a todos.
Good morning, everyone. It is a great pleasure to once again be in this Congress. This is the 10th edition of this Congress. Putting up congresses in Brazil is very hard. I was also a planner, so putting up an international congress on tax law with a number of guest speakers and professors coming from around the world to share ideas here is another challenge, which is really huge. I would like to congratulate all the planning committee of here, of this Congress and also on behalf of Rodrigo, Flavio, and Dr. Sherrod that made it true. Also, I'd like to congratulate or to greet my colleagues at the panel, Marlene, Daniel Prentice. I wish that all my cases would be judged by him because, he is so serene, and also he does a very in-depth examination of all the cases. Bruna, Laura, Victor, it's a pleasure to be here with you. I'd like to start by telling you a story, the story of my life. I started working in the orange export company, which is a commodity. It was 40 years ago. Well, 40 years ago, maybe a little bit less, like 38 years. In that company, I was charged with the task to establish the price of the transfer price to the US and Germany. At that time, there was no specific legislation for that. The legislation dates to 1995, but it was very effective in other places. Then there was a shipment sent to the US, and then there was a problem with ice in Florida. The price had just boosted, and then I priced that ship, certain that a good result would be in view of the reality that we saw at that time. 6 months later, you know, the oranges had not been sold, and then the prices started to get down. Of course, because of the ice problem was not really that major or that horrible. And this is why, of course, this generated loss to our branch or the American subsidiary. And the American IRS went to make an inspection to see what had happened, or more objectively speaking, whether Paulo had made a mistake. So what was at stake at that time was not the result of that report, was really my job. After 1 year, you know, just by taking all the measures that the Daniel said, getting to know exactly when the contract was signed and what was the price on that occasion, and etc. So luckily, there was no problem, no fine applied to that, and I kept my job for another 3 years. Well, I'm still in the office today. So this is how I faced this issue of transfer price for the first time. And then in 1996, when the legislation was passed here in Brazil, I was in my master's degree course, and then I tended to write my dissertation on that topic. In that same period, Professor Schrader did or wrote his book on this topic, which is really a Bible in this issue here. I was really critical with regard to the Brazilian legislation on that occasion because I understood that even though there was a reference in the legislation to the OECD rules and the principles, the arm's length principle, but actually what we had were several other fictional elements that could be considered relative in some cases, but absolute in other cases. And therefore, it causes some uneasy situation with regard to the income in the transfer of income. So that legislation was very strict and very, so to speak, constrained. But there were challenges faced by that, like Daniel mentioned. So each product is a different one, and each company has a different reality, and each international framework has its peculiarities. So when you try to take all this complexity and just put that in its little boxes, so there are very big chances that you do not really can put in all these boxes, and then you have an overflow of other rules. So this is why I criticize the interpretation that required a strict enforcement of all the methods. And also, we should admit, or I admitted later on, according to the Constitution interpretation, that the method should be considered as being suggestive. And as I learned from Professor Schroeder, I think that there should be a safe harbor of this. So in this case, I have the right, constitutional right, to prove by other means and proofs that the results were not manipulated and they did not do anything, and they did not earn any money unlawfully, and that was really applied the law to that according to the definition of income according to international law, and then I also applied the concept of international concept on the generation of income as it is in our constitution. So we could choose method according to this logic, which was very strict. In 2012, then we have the decision to treat commodities differently. So then we have the sixth method. It plays a challenge, which was to place the world in a line in a very strict way, and this also just repeated the situation of ADP sex. So when we say that we're going to start from a stock exchange parameter in order to price a commodity, something that is not to a party that is not related to that, but it's caused a lot of problem. But this did not happen like that because each product or each company has different products, each product has peculiarities and so on. So then we go back to the orange juice. When we sold orange juice to the US, they had one reality. Then when it was to Japan or Asia, it was in drums, and to the US, it was in bulk. So when we had to remove the orange juice from the drum and so on. So we have to consider all these realities. If we don't do that, the situations will be completely different. And the stock of New York Stock Exchange market works very differently from the other ones because it belongs to a country that produces orange. So if you want to apply a very strict rule to pricing, and also when you consider something that is more important, the adjustments to be made is even more complex. And now I answered the question that was made to me. So this is something that cannot be interpreted in a very strict way, or something that is too much geared to the word by word of any legislation on this topic, and especially when it has to do with all these normative instructions about the legality of all these processes. And this is what we had on that historical moment. There were pre-established methods that were kind of strict, and all of them also were in light of a very objective legislation. And now I would like to place myself next to Daniel because I also have this question. Is it worthwhile regulating everything? Or given that now we have something based on principle, maybe it would be better not to regulate things. But when you regulate things, all the discussions are around the verbatim things related to all the IRS procedures, and also on the judgment of tax issues that apply to CAF or GARF. And then we had all the editions of normative instructions showing that IRS wants to limit subjectivities or subjectiveness, and sometimes limit some certain attitudes that is totally mandatory so that we can compare things that have a minimal logic to be compared. And then here we have lots of different instructions. We cannot really elaborate on them, but this shows the extent of this reality. And we also face several challenges like market premium, and if we could just not consider the logic or the principal logic of taxation in this case, based on the fact that there was a concept of income, or there was a definition of income in terms of taxes. And sometimes what we also feel is that normative instructions that are careful and trying to show what is the margin that a taxpayer can produce an evidence by an agency legitimized by the IRS itself in terms of transfer pricing, as we can see here in Article 34 of the normative instruction 1312. What we see when they are enforced by authorities that this possibility are simply ignored as if they were mm, forgetting that they were legitimized by the IRS itself. So many times you have to judge something in which the price is referred by a foreign exchange market, stock exchange market, and then it can be Germany, US, whatever. And then the sales is based on FOB Brazil or FOB Brazil. And then you see, oh, this is FOB data here. And then you have to compare that directly. But how can you do that if the product has to go to the US or the Europe? How about the freight? Can we just ignore it? No, this is FOB and so on. Anyway, so here it seems that I'm telling a lie, but it's not. This is something that we experience in my practice. Okay, so then we have this movement of just getting away from the legislation because it wants to be practical and because the IRS did not have the framework according to the ones practiced in the Europe and the US. So then we tried to join the OECD, and then there were some other issues that are in this law 14596 of 2023. So this is a legislation that is much more based on the principle, which is more subjective, but also will put the taxpayer and IRS in a more, safer way. As Professor Sweater said, you know, it seems that it's going to be passed in 2026. Not 2025 is not really possible because he's been working a lot, especially because of these landscapes now. Because the method here would not be that strict. There is no subjective rules. Because if applied, they're going to make things easier for the taxpayer and the IRS. The problem is how you enforce that, how appropriate they will be enforced. It's impossible for you to be there everywhere, but many times there are certain things that are relevant to consider. So I like this idea and the logic applied to that. I believe that we have theory instrumentation that is very good to base or to provide the grounds for all of this in terms of adjustments. I think that this shows an evolution to what Brazil has in terms of going to the OECD, but also making our legislation more coherent in terms of what we seek in terms of fighting against manipulation, and also to have legitimate comparisons that will allow us to confirm that whether there was a manipulation or not. When we just move away from an objective rules, we also have a better potential to produce an evidence that should be very well developed. And of course, we're also going this will also give a lot of work to all the consultation advisory companies and all the companies too. Because decision-making process will be more effective, I think. I think that the legal basis for this also gave way to some adjustments that were questionable before, but now these adjustments should have already been adopted in the previous legislation, and under no condition I can show an adjustment that can compare different realities on paying that you tax an income that is on assets. So this was also present in the previous legislation, and now it's just going to be maximized in the new legislation. Vito will speak about the netback adjustment, but there are several adjustments that will have to be made. And these adjustments are not restrictive, or they are not just limiting, they just work as an example. So this is what you see on this slide. Whatever you can also create and also can be present in the evidence submitted by the taxpayer. So, in a nutshell, and I know that time is very important, so I think that law 12715, when it's correctly interpreted or construed, would allow us to make all the adjustments that are relevant and in order to allow us to make comparisons of different realities. And the new legislation is more eloquent and clear in this sense. It is more based on the principles, and therefore it should just replace this type of discussions that we have had. Of course, it all depends on how we play the game. In one of the previous congresses that we had here, the topic was enhance the relationship. So this means how can we improve relationship between RRS and taxpayer? This is what Mariana also addressed in her initial talk. I think this is important. I think that this relationship should be improved and should not just be based on the logic and consider a landscape in which what is important is to find, regardless whether it's good or not. So I think that a, a legislation more based on concepts and principles and less restrictive can allow us to have a better control and more challenging control of uh, transfer pricing. But I think that in theory, this can also better reflect the reality of each product, each company, as Daniel said. I do hope that this is the scenario that we have, or something more evolutionary, as was said before, something with a growing challenge that would allow us to have more discussions on international taxation in a more based on science and in a better structured way. Within a couple of years, I do not hope to be here, or I would like to be here to remind you of, like Belchior Singer said, despite we did everything we could, we're still the same, and we lived as our parents. I hope that I do not have to say this when I come back here within a couple of years.
Oi, pronto.
Thank you, Professor Paulo. Now, moving forward with the subject adjustments, as it was said before, considering one of the possibilities of comparability is by adjustments, what are the cares and risks that taxpayers must take into account when they do the functional analysis, looking for the relevant characteristics for the setting forth this price to be control transaction point was accessible regardless of the transaction value. No other part of the value chain will not affect reliability of the PIC method. Comparable uncontrolled prices unapplicable when we have a productive process that will affect the product, might be a customization, production. So the taxation of a tax paying capability. Well, perfect. Thank you, Bruno, for your remarks. And let's see if we can address all here. I would like to thank on our behalf for the invitation and congratulate all the panelists, Professor Paulo, Laura, Daniel, and the IBDT board peers on the department here of this university for the privilege to be here now and share some ideas with you. It's a joy, huge joy. It's the 10th Congress of International Tax Law in the day that IBDT celebrated 50 years. So I think I participated in 25 of these 50 years. So as a student, since then I have collaborated with some projects over there. Your question, it's quite challenging. Let's see what we can address. I selected three subjects focusing on the practical aspects of the new legislation. I'm going to talk a lot about commodities, but intangibles also. And today I think it will be the day we will know if the Colombian coffee is different from the Brazilian coffee, like OECD thinks. Well, the legislation talk about net back adjustment, as Bruna formulated her question. This changes completely the line of thought regarding transfer prices regarding the export of commodities. By 2023-22, we have the sixth method involving a export of commodities only getting the quotation price, listed products, listed stock exchange, and mandatory obligation. The sixth method is not one of transfer pricing, is not one that caters for the arm's length principle. It is a forced rule, anti evasion, protecting the tax base of commodity exporting countries. But it was a methodology quite ordinarily adopted by commodity exporting countries. It was how it was projected by Argentina a long time ago. That's the idea of the sixth method. But it's quite clear. The sixth method is dead. This method has ended in Brazil, Argentina, Colombia, and it will end in other countries of Latin America like Peru. I'm not sure how it's in Peru right now, but they have a better situation now. And the new rules, they present a good balance. This method involved using prices absolutely apart from the reality. Sometimes the exported product was not the one in the stock exchange. It many differences to take into account, and therefore some adjustments to be done. As of now, and I add one more component for the blue group, many Brazilian exports are selling to traders that sell to orange clients. And what we have now, probably the arm's length price, the true market price, is the one at the end, the point, not the price at the exports time by starting in Brazil. So, Bruna, in fact, the assessment price of commodities ideally think it's not the shipment exit point. Many times this in practice is captured through the contract. Independent third parties would be concerned if the selling in the future will vary too much. Prices change drastically, and it's very important to have the knowledge. Exporters of agricultural or materials, they must know how the market behaves, even not to lose money. So our new methodology involves using a PIC method, hub method, with the clear adoption of the arm's length principle. That's why I say cup plus arm's length principle method. Pick with the principle of arm's length. So the article 1415 of the law sets forth clearly, if you apply PIC or any other method, it is important to guarantee the arm's length principle is being catered for. And how this is done, understanding how the market works, taxpayers, and the only momentum where the law uses the expression chain value is the commodities chain. Taxpayers must explain how their business work and how they pricify for their clients. The pricifying formula must be known. Many companies, we have experienced this, they feel a bit uncomfortable with this level of transparency, but it will provide good, so we can in fact price properly exports. And this is a point I want to emphasize with all of you. The price will drop. Probably export prices will drop. If I use the stock prices at the export point, when you use the future export price of the second blue company selling to the orange company, probably I have to add other things that happen in this chain, even the profitability margin of this trading. So let's see how this happens and how can we use the future price in the chain, not future market, but in the chain in a situation like this to know the export price. The idea, net back adjustments idea, is precisely following this concept. I don't know the price in the end future point of the chain. Let's discount what's happening in the assessment point and export point to reach a price that it's the right arm's length price. This is the Brazilian norm in Brazil. Spain net back adjustment is explained by the law setting forth that we have to do an analysis of value chain analysis, and the normative instruction provides two examples. I will address two. If the same taxpayer exporter sells the same product to two individuals, one for the group blue group and the other one the third one, the sales condition for the orange entity is CFR. CFR freight is 100. It's easy to remove 100 from 1,100, and we find the export price without freight should be 1,000. And it goes. It's very simple example to understand all the price components to do the retroactive adjustments, which are the net back adjustments. And now, clearly, we are talking about identical products, the same products, so adjustments are related to contract conditions, transshipment, and things like that. Now, as for chain selling, where I have mine and refine in Brazil and refinery abroad, the example two of the attachment will address differences between refined product and gross product, and then it would be important to how much refined export product becomes a 1 ton non-refined product will how much become refined product in the example the conversion rate is 50%. It will be understood in this attachment. It's not said, but it's understood that the exporters export 2 tons, so the refinery company could reduce to the 1 ton refined product in proportion. So this will end that we know refining cost by ton. We can specify the export price. Each ton, if I need 2 tons to do one, and the final price is 100. In fact, discounting, doing a net back, removing 15, removing 2 times 15 because this is the price per ton, and the refinery refined 2 tons, so removing 2 times the 15, I can reach the 35 price for exports. I will not digress too much in math, but you can understand. When the product is not the same, difficulties are bigger. So getting the logic of the price and the posterior point of the chain in bringing backwards the net back adjustments, we have so many challenges posed here, but it is hoped and it's known that several sectors of commodities they have the knowledge of how this works, and the exporter and the mine they have tested in practice to celebrate contract with net back pricing. There's a clear example from the 80s involving Arabian countries where the price formulation clause had 70 pages in a contract of 120 pages. So all this knowledge here are important to reach this point. This is a very simple example. Now, the production chain, refinery, thinking about ore, everything it's also applied to agricultural commodities involves several activities, and many of them might be rendered by different entities in the production chain with the same multinational group. And in the analysis of transfer pricing of the new legislation, it is important to do the functional analysis of each one of these phases and understanding their roles. And I focus now on the trading companies. What is the role of trading companies in commodities export starting in Brazil? Because by the end, how much profit should remain with the trading company? Now, with the functional analysis for each item an entity in this chain, I know that it's a small letters I cannot read, but I call your attention the materials available on the right hand side, last column. We have the trading company. This is a list of the assets used in such activities. I don't want, of course, to do a comparison only with figures, but the amount of assets, capabilities, knowledge developed by trading companies are high in numbers, important in value creation and the certainty of right pricing and profit generation within a value chain involving commodities. The same thing for risk typically found in mining. This is an example of functional analysis that are well known. These examples are quoted and I showed the material by the end of my presentation. And I don't want to give you the idea that all trading companies are the way I'm showing you. It's not this. They would be, in fact, trading companies the highest level of functions and risks that they might incur. In this slide, you can see trading companies on the right hand side. The more risk they have, yeah, we think about trading companies, we think about risk of inventories, non-selling, non-delivery, or cost. There's a credit risk, many things. So you can see here they're flagged. The example of petrol in 020 was negative, the easiest one to understand. Back then, I don't remember, March 20, it was caused by the pandemic event. People were paying to receive petrol. So you would receive many money if you're capable of receiving a petrol container in your home because people didn't have where to put it. So imagining trading companies that buy and sell and remain with inventories like orange juice, as Professor Iris mentioned. There are lots of inventories of sugar, orange juice worldwide, so risk incurred if trading a position this way, they must be remunerated. There's a share of profit that must be allocated for the trading company. The transfer price legislation role is to divide correctly and fairly business profits, and we cannot deny this important role of trading companies. In this screen, also, it's impossible to read and is part of a specific material that was made lately for the commodities area. We can see the level of importance, and those above are more important and below are less important regarding trading companies' role of negotiations and knowing their own market. And of course, this generated regarding the excise a huge concern regarding what the trading company is doing. Generally, these companies, they are in favorable taxation countries or favorable tax system. What can I do? What, so what? It's not the legislation of transfer pricing role to do this and care for this. There are other ways of dealing with this, including the legislation of Pillar 2. There's no way to question with the transfer pricing legislation, ignoring the role of a trading just because it is located in Dubai, Abu Dhabi, Singapore, somewhere like this. And there are other ways of doing this. The important is to understand what trading companies do. How many individuals in these companies, experts, do the exercise an important role. So trading companies do marketing, but there's also a marketing team in Brazil. What's the most important marketing team? What is it exactly the trading company doing regarding risk? Does it have risks of not selling? Are risk A, B, D, inventory risks, and so forth. In a study conducted and near market to the mining sector, and here we're talking about some ores. I don't want to put this in fire. This is the African market. It found out that the tradings do something between 2 and 6% between in the net revenues, or 2 and 8%. Obviously, there might be scenarios where it's a bit beyond, a bit below, and then, Bruno, the most interesting thing that part of your question talked about, we're going to enforce peak ahead in the chain. I don't know if by the end what we do here it's the pick or cup method because I get the selling price might be actual, it might be quoted in the stock exchange, and then I subtract something net back adjustment to reach this price. It seems to be reselling price minus profit. So pick with PRL mixed with in fact TNM to know the profitability of the trading might be the TMN method. So it's sort of double twist and carpado method. Always a doubt how the translator is dealing with this. Well, I think we're doing fine and fantastic work people can. One of the most smart things a human being can do, thinking in two languages. Thank you. Therefore, to a few words regarding royalties, a subject that we have seen a lot. Is important for Brazil because we just release ourselves from fixed limits. So how much I can pay? If we do a transfer price study and compare contracts here, providing a TP Catalyst tool, and TP Catalyst tool, and I have friends from TP Catalyst peers in the audience, and we have used this in our transfer price courses. If we do a study here, not very detailed, we will find the interval between the quartile, allowing royalties to be fixed in 10%, 30, 15, 20. You choose several figures possible for royalty, and the interquartile interval is high. So we have to do an improvement here to fine tuning and understanding better this contract. My question is, once you define interquartile interval and studies have it between 2 and 10, just to have a number here, how much I know how I can charge? Then can I get the highest number and just use it? I would like to share with you, just to quote or share the knowledge of the existence of this sort of approach. It's important to mention, we hope the legislation of Brazilian people like the normative instruction. We know we send signals what will be the excise view regarding certain rules, and to know how to behave before this is important.
Even though this is just for the legislation to be drafted in a more generic way, but this is way anyway, it just steers attitudes. In Brazilian legislation, we have no explanation on what happens in the interquartile interval. So anything will be valid, but and according to the international practice, it does have something that will imply. So we have to define the intrinsic price of royalty. So what makes sense to charge? I can charge from 2 to 10, but I'm going to charge 4 because considering three different perspectives. Cost, for example, how much the group has invested in research and development, and what is the hub of technology that will have to make profit. So we make a cost analysis. So return on assets. Model 2 is considering how much result of that technology yields. And then there are some gross calculations or the rule of thumb calculation or guessing calculation. So usually we have a 25%. Usually this is the percentage that you take. So this generates a 10% margin. Then you have other percentages to be applied. So this is just a very gross rule to be applied. And we can also use comparisons with the market. Of course, I don't want just to credit technologies that are very innovative and unique, and they really deserve to be used. So these are the main materials used in the data demonstrations that I showed you. And with this, I would like to close my talk, and I have exceeded my time by 1 minute. Sorry. Thank you, Victor. So certainly we have a couple of comments to make on this, on your jump with several twists and so on. But now, Laura, we do want to hear you, in particular considering that Colombia has introduced a legislation according to the arm's length principle since 2002. So for 20 years, you have already applied it, or 22 years, you have used it in domestic legislation. So with this, we want to hear how Colombia has assessed the main issues and controversies related to all this period of adaptation. So 22 years, you have been doing that. We are just in the first year of that. So we want to learn from your experience. With regard to commodities, which has been the main topic of this panel, also, we want to hear your view on how Colombia has used this most appropriate model. So, is this made under the legislation, and how do you use a cup or peak for the quotation price? But Colombia has never used the sixth method directly, even though other Latin American countries have used it, but this is not the case in Colombia. Even so, I believe that there are some controversies with determining price, the interval to be used, and the dates to be considered to specify the transaction. So I will appreciate if you could elaborate a little bit more on the experience and also experience of Colombia.
Thank you also to the Instituto, to my co-panelists, and to all of you. So I would like to begin showing some data. The source of this data is the webpage of the CIAT organization that was shared by the Colombian Tax Authority and the Brazilian Tax Authority. Even though we only have the Brazilian information until 2020 and in some cases until 2014, and I actually encourage Daniel to share with the CIAT because it is very useful for taxpayers and for tax authorities. I still think that this data that I'm showing is useful. In this first chart, we have the request for information from other tax authority regarding transactions subject to transfer pricing. And we see, for example, in 2020, that Brazil, the number of requests that Brazil sent was 4, and the number of requests that Colombia sent was 45. And in the same year, the number of requests answered by the Brazilian tax administration was 4, and the number of requests that Colombia answered was 3. I actually think that the area where the Colombian Tax Authority requests the most information to exchange is in transfer pricing, and I think that might be because they know that it's easier to collect money through transfer pricing audits than to abuse audits, because in abuse you have to, the tax authority have to prove the purpose, and in transfer pricing they don't. So next we have the number of transfer pricing audits in 2015, that is 21 for Brazil and 47 for Colombia. And if you see for 2014, there were 61 for Brazil and 135 for Colombia. And then you see for that same year, the amount effectively collected as a result of transfer pricing adjustments on those audits. And you see that Brazil, with only 61, was already collecting that number, that amount. So what it would be expected is that now Brazil, the tax authority, the Brazilian tax authority gets to do more audits and then collect even more. And then here we have the economic sectors with the highest risk of transfer pricing manipulation based on their impact on the economy and or their behavior, as to what the Brazilian and Colombian tax authority think. And we have that both countries include mining sector on those highest risk of transfer pricing manipulation. And then here we have the transactions identified by the tax administration that might be BIP. So we have for both countries the use of traders in commodity sales. And for Colombia, we also have payment of royalties, and a free transfer or assignment of intangibles. So entering more into commodities, our regulation currently has a specific definition for transfer pricing purposes of what a commodity is, and it is a physical product for which independent parties use quoted or listed prices as a reference. We don't have a specific list of commodities by law, provided by the law, but the tax authority have a list of proposed commodities included in the form in which the taxpayer filed the PT return, and currently includes also orange juice. I remember that because the story of Paul. We also have that when dealing with commodities, that is like the specific article. When dealing with commodity transactions, COP will be the most appropriate method, and it should be used to establish the arm's length principle in those transactions. We have only 2 exceptions provided by law, and there are like where where it is not possible to identify the factors that constitute the listed prices, or in the case that such factors exist and require comparability adjustments, but those adjustments cannot be measured or quantified. Now, although the Colombian legislation almost make mandatory the use of COP, and this is really important for transfer pricing in Colombia, and that is like the tax courts in Colombia play a really important role in the transfer pricing area, because they end up like modulating some of the regulation, and this is one of the examples, because even though in the law we have almost mandatory the use of COP method, the tax courts provided actually recently that there is no prohibition of using another method, and the only thing is not little, but the taxpayer, when using another method, have the burden of proving the reasons, the reasonable reasons to use another method. We also have, or as to the necessary documentation, we have that the agreed date or period of the price must be supported by reliable documentation, that is the contracts, the agreements, the offers, the acceptances, and so on. Otherwise, the date of shipment would be applied by the tax authority, by the Colombian tax authority. Based on that, agreements regarding transactions with commodities have to be registered. That is what the law provides, and also in that we have like some pronunciation of the tax court. The tax court also recently stated that it is not mandatory always to register the agreement, but only if the taxpayer is using COP. Nonetheless, it is advisable that every taxpayer register the agreement, because if the Colombian Tax Authority ends up proving that the best method or the suited method was COP, then it would be better to have already registered the agreement. And also, the tax court stated that if the date of the agreement loses reliability, then the taxpayer also can submit evidence on what the date should be. So that's what we have currently in commodities, and this already present lots of challenges for the tax authority and for the taxpayer, but we always have had actually like these difficulties, and specifically in extractive sector, because we used to have that the Ministry of Mines set the average price, that it should be used between the Colombian taxpayer with its related party, its trading related party, and the way the Ministry of Mines calculated that price was based on the information the Colombian taxpayer provided from that related party, and the ministry would take it from CIF to FOB, and we had actually currently, because tax courts takes long time to decide in Colombia, we have lots of debates on this, where, because Diane usually wanted to make the prices that were below the average to the average, but then keeping the prices that were above the average. Tax courts decided that was not correct, and even later there was even more favorable for the taxpayer decision of another tax court that said that, because the Ministry of Mine usually took like 6 or 8 months to decide what the price was, and the tax court decided recently that if the taxpayer didn't have the average price set by the ministry at the time they were filing the return, then they could use the real price. So as to intangibles, we actually don't have much in our transfer pricing regulation, but we do have some regulation and some limitations regarding intangible, and that ends up relating to transfer pricing. For example, we have that an intangible contribution from a taxpayer to a company located, a foreign company, would be deemed to be a share purchase and would have to comply with transfer pricing regime. We also have some payments that cannot be deducted. For example, royalties royalties paid to a related party on an intangible that was originally created in Colombia. Also, we have royalties related to importation of finished product. We cannot deduct that. And the Colombian taxpayer cannot take also the amortization of an intangible acquired to a related party. Just the last one is the only one that that cannot be, I mean, that the taxpayer is able not to have that limitation if the taxpayer comply with the transfer pricing regime and also with arm's length principle. But the other ones remains even though the taxpayer proves the compliance with the arm's length principle. We have also that currently the tax authority is challenging the deduction of royalties always if Colombian taxpayer has also losses and or pays for marketing, for local marketing expenses. That actually that those expectations of the Colombian tax authority are really not like in line with arm's principle, because if I was paying a royalty to an independent party, I cannot excuse myself from paying the royalty only because I have losses in a specific year. And also, if I am selling a product that contains a brand, whenever I make local marketing expenses, I am not behaving necessarily as the owner of the intangible because I just want to sell the product. Since the common denominator in digital business is the presence of intangible assets, we have to comment on the recent developments in Colombia inspired by Pillar 1 and Pillar 2. We currently have a regulation on significant economic presence, not only for related parties, not only for digital services, but for all services and for all goods. So we have a new source rule including the revenues by those sales by non-residents or entities that are not domiciled in Colombia with significant presence in Colombia. The activating factors for that presence are revenue threshold, as you see, the interaction with Colombian users, and also showing prices in Colombian pesos or allowing payment in Colombian pesos. The collection methods are filing for them to file an income tax return with a rate of 3% or a withholding tax of 10%. That was for Pillar 1. And for Pillar 2, we have our own minimum tax rate at 15%. And actually, yesterday, the ministry filed a yet new tax bill for Colombia. And they are proposing that the minimum tax rate begins to be 20%. So we have to see. So we have that minimum tax rate with no threshold. This minimum tax rate applies to everyone, to every company specifically. And we don't know if it will get to be considered by the OECD as qualified domestic minimum tax, because there are some characteristics or requirements that the OECD have included for being considered as a qualified domestic minimum tax that we do not comply. For example, the law of this minimum tax rate in Colombia doesn't take into account the temporary differences. So that's really huge. And also, we were debating also on APA because since we have the regulation of APA since the beginning of transfer pricing regulation 22 years ago, they thought that maybe I have something to share, but actually in Colombia we have the opportunity to celebrate APAs 22 years ago, but we only have one celebrated in those 22 years. We have a procedure initially that takes 9 months, but usually takes more. The taxpayer doesn't have the opportunity to appeal any decision or action that the Colombian Tax Authority made in the procedure. It can cover up to 5 years. And if the APA is concluded, no local file will have to be presented, just a report of the compliance on the APA, but the Colombian Tax Administration can ask for the local file, and the taxpayer will have 2 months to file. I think I would skip this. And so this is, I think, maybe the reasons why I think we only have celebrated one APA. Maybe I think it's for the uncertainty that we have. It is a long process. The taxpayer don't have the opportunity to appeal. And again, I am using a chart of the CIAT webpage, and this shows the required documentation in those countries. And if you see, only Colombia and Jamaica are asking for everything. they possibly can. And also we have, and this is the part of the uncertainty, this shows as if Colombia will only use the information attained through APA negotiation only for those purposes, but actually the law in Colombia provides that if the APA is revoked or canceled, but this is the important part, if they think the information provided by the taxpayer might possibly stand for a cause of abuse, then they also can use the information in other aspects. We don't know in which one, because we don't have like the experience, but by law, without proving the abuse, only having one possible cause of abuse, then we know that secret information won't be no longer like secret. Thank you.
Muito obrigada.
Thank you, Laura. Taking into account we still few minutes, I will pose some questions, but I would like to thank you because now we are talking and addressing exactly as we have a public consultation open about APA, and some of the main points that yesterday we talked with Claudia and Danielle also is here was regarding some issues you addressed that leads to a huge uncertainty regarding the current model of price anticipated agreement. Now I would like to use the few minutes we have on posing questions to Danielle. Please answer some of the questions posed at the beginning. First question, Danielle, and joining with the part you anticipated, but I think a huge doubt regarding taxpayers, specifically regarding commodities. When we think about RTC transactions negotiated in 023, but exports made in 2024, and the contract was signed in 023, and exports in 024, must they be reported in the RTC? Plus one previous question. Big doubt by taxpayers regarding a forward contract. I negotiated in 023. The shipment date would be later in 2024. I did not do the anticipated dosage. I don't have a ground rule. Am I obliged to ratify and renegotiate this contract? Or it was done the date it was signed, as you mentioned, it would be an important point to define prices, would remain applicable in 023, and pegging this to the conditional circumstance in AN 261. We foresee this. Thank you for the question. I will answer briefly, and I would like to say something regarding trading's remuneration adjustments. According to my understanding, the new rule is applicable for those contracts negotiated before the effectiveness, or whereupon the revenue is recognized during the effectiveness of the law, i.e., contracts pricing for income tax filing, probably they must be reviewed. And this directly impacts the RTC. These transactions should be declared on the RTC. I think I have 2 minutes, and I will also talk about the trading adjustments. This is because it's one of the most touchy points for the inland revenue regarding commodities transactions. In Brazil and other countries also face serious problems of abuse regarding structures with middlemen in general. We know the middle agent, it's very common for commodities. It's what they do always, but I think according to the former legislation, we saw something more peculiar, the use of structures regarding places which are not those normally used by companies. Turks and Caicos, as an example, beautiful island, but deep down they have no expertise regarding this market. And we recognize that the new system must remunerate all the value chain function, inclusive the one of go between in function of those who are commercializing the product. Many times what we see, the function is not performed by the middle company. It is done by those in Brazil. located here. So this is another point that we must be careful. Now, we must in fact analyze what this trading, the middle man, the risk and what they're doing. And then the second question, how to remunerate in some cases when you apply the comparable uncontrolled prices peak, you have the related part really exported in Brazil and the selling by a third party. This arbitrage, this difference, it's not sufficient to remunerate the intermediary agent. I place this question. Furthermore, am I going to include any additional remuneration? We must be very careful by assessing this. Another question is how to remunerate. Do you think a percentage as a commission on selling price, it's always the best price? Does it truly bring the arm's length outcome? There are those cases in Australia where they use a Singapore trading company and the percentage was 2.5% on the gross revenues of selling price to the third party. When you compare on the other side another profitability indicators of this trading, you can see the margin over operational expenditures was 600%, which is not compatible this margin with the sector. Not even the IT sector you have a margin of 600%. So there are the things that must be analyzed within this point, and we must be very careful. The new system is more fair, but this is a very touchy point, and we hope that we have it receives the due attention. Thank you. Thank you, Danielle. Now, due to time constraints, I thank you very much with what you shared with us, IBDT, USP, for the invitation, possibility of being here today. Congratulate you all again on this panel. Now I declare